And I want to start with 3 or 4 propositions. One is that there's nothing inherently unlawful about using drones. 2 is there's nothing inherently unlawful about targeted killing per se. In an armed conflict, the alternative to targeted killing isn't no killing, it's indiscriminate killing, and that's a war crime. And there's nothing inherently wrong in the concept of what you heard Jim talk about as signature strikes. That is, we don't know who the person is, we just know that they're doing certain things, or we have a certain degree of satisfaction that they're doing certain things that we attribute to bad guys or terrorists. And that may be also particularly questionable in terms of what the evidence is that we're using, but there's nothing inherently wrong with targeting someone on the basis of evidence that, say, doesn't include knowing who their names are, but knows what they're doing. From these few points, you might conclude that I'm a big fan of drone strikes. But in fact, I agree with everything that Jim said. And the reason has to do with the particulars of international law as they should be applied, as opposed to how they are being applied by the United States. There are 2 major frames of international law that can apply here, and they can overlap. One is the law of armed conflict. The other is the law of human rights. Now, in a war, targeting and killing are lawful. But before you can say that you have an armed conflict to which the laws of war are applicable, certain conditions have to be met. And it is in the meeting of those conditions that I think the United States is taking great liberties with its targeting claimed authority. One is that to have an armed conflict, you have to have parties. You can't just have bad guys. You can't just have militants. You can't just have terrorists. You can't just have insurgents. You have to have parties to an armed conflict. Those parties are defined in accordance with their capability of utilizing and having a command structure through which the laws of armed conflict may be determined, may be implemented. And if an entity is not sufficiently formulated so that it doesn't have a command structure, it doesn't have a hierarchy, it doesn't have the capacity, whether it wants to or not, to comply with the laws of armed conflict, then it isn't a party to an armed conflict. And it may very well have been that on September 12th, 2001, there existed an entity called Al-Qaeda, which could be determined to be a party to an armed conflict, but whether or not such an entity exists today is highly questionable. Second, in order to have armed conflict, even once you have parties determined, you have to have a certain threshold of hostilities that are taking place over time. If you don't, then it is merely domestic and criminal law mechanisms that apply. If we didn't have that threshold requirement, then there simply would be no ability to distinguish between when killing is allowed in a rather promiscuous way that the laws of armed conflict allow it to exist, and the more limited ways in which killing extrajudicially is allowed in a criminal justice framework. We cannot cross those barriers willy-nilly. So although I have no problem with drones per se, I have no problem with targeted killing per se in armed conflict, there's a great deal to be discussed, debated, and as Jim said, one of the things that has simply not appeared in the debate, as important as it is this question of whether or not we ever were, and even if so, are we still in an armed conflict with the people who are the victims of targeted killing? Second, even if we do have an armed conflict, even if the context is one of war, the laws of armed conflict don't allow you to kill anybody and everybody. The most fundamental principle of the law of armed conflict is that of distinction. Distinction between what? Well, between combatants and civilians. And that's easy enough to determine when you've got Army A lined up against Army B on the beaches of Normandy. You know who's who, and you don't have to worry so much about distinguishing between civilians and combatants. But the kinds of warfare that take place today put an extra onus on parties to armed conflict to distinguish between combatants and civilians. And the laws of war require that if you are not sure whether someone is a fighter or not, you are to presume that they are not. The United States' criteria, what we know of it, for determining A, that there's an armed conflict, and B, that the people that we are killing are indeed killable in the frame of that armed conflict, simply do not comport with, do not rise to the level that is required by the applicable international law. Now, what about outside of armed conflict? Because surely a police officer can kill someone who's holding a hostage, say, without necessarily bringing that person to a judicial officer and having him or her charged with a crime and tried and convicted. There are circumstances in which lethal force can be used, again, extrajudicially. In international law, there is the recognition of the right of states to use force in their international relations when they are faced with an imminent threat. The concept of imminence is the key to the determination of when and against whom a state can use force in its international relations. Today, what we're seeing is a redefinition, a redescription down to just about zero of the concept of imminence by those who have spoken on behalf of the United States on this issue, such that we no longer have to have a recognized threat. We no longer have to have an existing attack. We no longer even have to have a recognition of a particular individual posing a particular danger that could result in lethal consequences to the United States or Americans. What we've had, for example, from Attorney General Holder is a statement that, well, we have to rejigger the concept of imminence to deal with the potentiality of the great threat of terrorism, and that potentiality requires us to not only look at how likely the threat is to manifest itself, but whether or not, say, we would miss a window of opportunity to take someone out who might do some harm to us in the future. Using that kind of standard to determine when and where individuals can be killed through the use of American force in international relations is disastrous. It's disastrous because it's wrong. It's disastrous because the United States, as Jim said also, correctly I think, sets an example by which other countries will determine their own interpretations of international law. These things have real consequences beyond the consequence to the individual that is being targeted. And also, I think, as found by many of the studies that have been done about the effects on the ground of targeted killings and drone strikes, there is the very legitimate question of whether or not these tactics create more enemies than they take out. So from the perspective of international law, forget policy considerations for a moment. While there's nothing inherently wrong with drones, while there's nothing inherently wrong with targeted killing, there's nothing inherently wrong with killing people even though you don't know what their names are, in other words, signature strikes, there is a great deal wrong with the present manifestation of U.S. targeted killing policy. And this is the reason why those of us who are doing advocacy in this realm are fighting so hard, first and foremost, for increased government transparency. Because we, at least as Americans, or I should say for anyone that purports to live in a democracy, have the right to know who our government is killing in our name, especially when they're doing it extrajudicially. The next frontier in this debate is going to be the one in Congress about whether or not we need a new authorization for the use of military force. After 9/11, the Bush administration asked Congress for authorization to use military force against terrorist threats rather generically. And Congress, even in the minutes or days after 9/11, said, no, we don't think so. We'll give you an authorization for the use of military force, but we're going to limit it to the Taliban, to al-Qaeda, to those who have harbored the individuals that are responsible for the 9/11 attacks. What's happening now is a debate saying that, well, the old AUMF is kind of long in the tooth. It needs to be revisited, and the threats are expanding. Therefore, we need a new AUMF that doesn't limit us to targeting Taliban and al-Qaeda, but to targeting terrorist threats more generally. This is an extremely dangerous idea, but this is going to be the next step and the next focal point of the debate, in which the question of the breadth of both targeting and detention will take place in the United States. And to the extent that authorizations for the use of military force either continue as is, or, what is even more concerning, would be expanded to encompass threats that aren't defined by the name al-Qaeda, Taliban, but say more generally what are considered to be terrorist threats in Somalia, in Mali, and elsewhere, unnamed threats. That is the extent to which the United States is walking very deliberately down the road to perpetual war. And that, I think, would be a great mistake.